New today, Donald Trump's stalled federal election interference case has come back to life 1 month after the Supreme Court ruled he is entitled to some level of immunity. Less than 24 hours after the D.C. Circuit Court of Appeals returned the case to Judge Chutkan's court, she has set a hearing now for August 16th. She also denied without prejudice Trump's motion to dismiss the indictment and advises he can file a renewed motion after the immunity issues have been resolved. Joining me now, Josh Gerstein, senior legal affairs reporter with Politico. Good to see you again, Josh. So, look, no one expects Trump's trial to happen before November. But how soon are you expecting Judge Chutkan to set a new hearing?
Well, we'll have this initial hearing, Alex. It's set for August 16th. So that won't be one that Trump will be at. It probably won't get into evidence in the case or testimony in any detail. But that session is where we'll be looking for her to consider when this hearing that some Trump opponents are referring to as a potential mini trial in the case would take place. And I guess politically, the big question is going to be, does she try to set that hearing for some time between now and Election Day? That seems likely, and if so, that would be, I think, quite a spectacle to be underway in the midst of the presidential campaign.
Give me a sense of who's calling for that mini trial, what that would look like, and do you think the judge is likely to consider it?
Right. So this is really an outgrowth of the Supreme Court immunity decision you referred to earlier. You know, they said that for core constitutional responsibilities, the president has basically total immunity and some kind of presumptive immunity, although it was a little vague for his other official acts. And so what Judge Chutkan has to do now under that Supreme Court decision is decide what portion of the charges against Trump potentially implicate official acts that there might be immunity for, as well as what portion of the evidence prosecutors would want to introduce might implicate official acts or constitutional acts by the president back during this 2020 timeframe. So that's a lot for her to wade through. And in order to do it, one way that seems like it would be possible would be for some of the prosecutor's evidence and perhaps testimony to be presented in court away from a jury, just with the lawyers and possibly Trump in the room. And then she would have to make a decision about how the immunity framework that the Supreme Court announced would apply in this specific case.
I mean, that is a lot to consider, but what about this? What's the extent to which you would expect the judge to take Trump's political campaign schedule into account as she's planning hearings?
So, you know, both the prosecutors and the judges that have been handling these cases have been very reluctant, I think, to grapple with this question of whether at any point the justice system should defer to the presidential campaign calendar, or as we have now, the situation where we're coming into really the final stretch of the presidential campaign. I think it's going to become difficult to ignore. There was an earlier hearing where someone referred to Trump's sort of day job or his professional activities, and that was sort of a euphemism for him being on the campaign trail. I think Chutkan's going to have to grapple with that in some way. To an extent, she already has. This hearing coming up on August 16th. She said Trump doesn't need to show up in person, but she'll have to make a decision not only on the timing of a potential quote unquote mini trial, but I think a pretty critical question, which will be, will she require that Trump be there in person, as she has the power to do? Obviously, that would be pretty disruptive to his campaign plans, especially if this hearing takes place, say, in the middle of September or the middle of October.
Yeah, absolutely. All right, Politico's Josh Gerstein, it's always good to hear from you. Thank you much.